Hi class, this is Dr. McGonigal, and this is video 2 for Chapter 7. We are talking about strategic issues in selection procedures. And in this video, we are going to focus on ensuring that predictors are fair and legally defensible. In terms of legal issues in hiring, there is a commission called the Equal Employment Opportunity Commission, and this is a government agency that is charged with monitoring organizations' activities in terms of providing equal opportunity to all groups such as selection, procedures, and pay. And I mentioned in our last video the uniform guidelines, and you'll see a link in slide 16. These guidelines were established to ensure equal access to job opportunities across different genders, races, ethnicities, skin colors, and national origins and religions. So essentially, the uniform guidelines were developed to provide organizations with a set of guidelines, a set of rules that they need to follow when they're using selection procedures to ensure that they are using them fairly and that they are not discriminating and that they are abiding by the Civil Rights Act, Title VII. So let's talk about the Civil Rights Act, Title VII. And this was an act that was passed in 1964, and it has to do with specifically employment practices. So the Title VII part of it has to do with the employment practices. This act bans unlawful employment practices on the basis of 5 protected groups that I just mentioned. These, again, are race, gender, religion, skin color, and national origin. The Civil Rights Act of 1964, Title VII, includes all personnel functions and it covers employers that have 15 or more employees. And so by all personnel functions, what I mean by that is it's not just about selection, even though that's what we are focusing on for this particular chapter. It has to do with selection, but it also has to do with training, promotion, performance appraisal, who gets discharged from an organization. All of these different personnel functions are covered by the Civil Rights Act, Title VII. There is one case where employers can get exceptions to the Civil Rights Act of 1964, and this is if something is called a bona fide occupational qualification, or a BFOQ. And these are fairly rare, but they are requirements of a characteristic that is necessary for the job. So, for example, for some jobs, for certain modeling, for instance, so if models are needed for women's clothes, for instance, they may say that a BFOQ is to hire a female applicant for that position. Again, these are pretty rare, but in general, employers are not allowed to discriminate on the basis of these 5 protected groups. Let's talk about some other legal issues in hiring before we return to some more specific issues around the Civil Rights Act. So one is the Age Discrimination and Employment Act, or ADEA, which was passed in 1967. And this extends the rights of the Civil Rights Act to people age 40 and over. So essentially it says that organizations also cannot discriminate against individuals on the basis of their age. So they cannot refuse to hire an employee, for instance, because they are older. The Americans with Disabilities Act, or ADA, of 1990 also extends the civil rights to those with disabilities. And there are a couple key legal terms to know about in terms of the ADA. The first is what qualifies as a disability. And this has kind of gone back and forth over time, and it has been recently updated. The ADA has been recently updated to make it so that it's broader, that more things can qualify as disabilities. And the reason for that is because a lot of lawsuits were happening and people weren't winning them because the courts were interpreting disability in a very narrow way. So essentially, how we define disability is that it is a physical or mental impairment that substantially limits a major life activity, such as seeing, hearing, walking, and other types of daily activities. And that includes working as well. Some conditions are thought to be automatically considered disabilities, and these include any type of condition that is terminal. So, if a health condition is known to result in death, then that would automatically qualify as a disability, and people who are covered by that would be given the same rights under the Civil Rights Act in terms of they can't be discriminated against. There are also some other major medical conditions that are included under that umbrella. The next term is reasonable accommodation. And this is referring to the fact that employees who have disabilities should be able to do their job duties either with or without what we call a reasonable accommodation. And organizations are required to provide reasonable accommodations when an employee has a disability. A reasonable accommodation could include, for instance, allowing someone to work from home on certain days, or allowing someone to leave work to go to a doctor's appointment and maybe make up that hour or two that they're gone at another time. So those are examples of reasonable accommodations. It could also include things like having specific software that helps someone with a vision impairment be able to use the computer. These are different types of reasonable accommodations. I actually do research on disabilities in the workplace, and one thing that a lot of employers don't know is that reasonable accommodations tend to be very inexpensive for organizations to implement. So I think sometimes there is a myth out there that reasonable accommodations are going to be unnecessarily expensive, and the reality is that most accommodations have been found to cost only $500 or less. So when companies have the opportunity to accommodate and to employ valuable workers with disabilities, they should really do that, and that is the law as well. The term reasonable means that the accommodation can't be unnecessarily expensive or provide undue hardship on the organization, and that's in the last bullet on this slide. And the term essential job function is referring to job functions that are deemed to be essential to the job through a job analysis. So certain tasks that have to be done. So essentially, workers with disabilities need to be able to perform their essential job functions with or without a reasonable accommodation, as long as that reasonable accommodation does not cause undue burden or hardship on the organization. All right, so what about gender identity and sexual orientation? So I am pleased to let you know that as of June 30th, 2020, which is not that long ago, U.S. federal law extends Title VII Civil Rights Act protections to people who are LGBTQ. And this was based on a Supreme Court ruling that happened over this summer. It's not a new law like the Civil Rights Act or the Americans with Disabilities Act is, but it was a court judgment that came down by the Supreme Court in favor of existing law, so the Civil Rights Act of 1964, covering LGBTQ individuals. So essentially, my understanding is that the courts found that the term gender would cover different gender identities and sexual orientations. And so, again, it's not a new law, but it does cover LGBTQ individuals in terms of protections against employment discrimination. Okay, so you may be wondering, how do the courts enforce some of these acts, including the Civil Rights Act of 1964 for organizations? And how do they determine what is discrimination in organizations? And so we're going to talk about two forms of discrimination. The first is called adverse impact. Adverse impact, just so you know, is also sometimes called disparate impact. So if you Google adverse impact, you might see the term disparate impact. To avoid confusion, we are going to use the term adverse impact in this class and focus on that. This is when one group as a whole is less likely to be hired in an organization than another group. And there are some key terms involved with determining adverse impact. One is the selection ratio, and this has to do with the number of individuals who are hired for a position divided by the number of applicants for that position. So that would be a ratio of how stringent the organization is in terms of determining which candidates are eligible for the job. The 4/5 rule is also known as the 80% rule, and essentially how adverse impact is determined is saying that the selection ratio for one group has to be within 80% or 4/5 of the selection ratio for another group. And we'll talk about this in more detail in just a few minutes. The second form of discrimination that we'll talk about is called disparate treatment. And this is a little bit more straightforward than adverse impact, and we won't spend a lot of time talking about it because it's straightforward. But disparate treatment is when a member of a protected group was treated differently due to their group status. So this is like when one person feels that they were unfairly denied an employment outcome, like being hired or being promoted or any of those employment functions, due to their gender identity, their race, ethnicity, disability, age, skin color, religion, or national origin. So I think when we think generally about discrimination happening in organizations, we probably tend to think more about disparate treatment. And so we're going to talk more about adverse impact next. There is a local case of adverse impact in the Charlotte area, and I want to introduce the topic of adverse impact by talking more about that case. So in 2013, Bank of America was forced to pay $2.2 million in back pay to Black applicants who were unfairly denied employment opportunities as bank tellers in their bank branches. If you're interested in reading more about it, there's a link in slide 21. I think I provided some quotes from the website that I provided there for you. And ultimately, the company unfairly rejected 1,147 African Americans for jobs, according to the Labor Department's Office of Federal Contract Compliance Programs Review, for the hiring periods between 1993 and between 2002 and 2005. So you can see that adverse impact is something that takes a long time to prove that it has happened. So it's not something that can necessarily be proven in one particular case. It is an accumulation of evidence that happens over the course of many years and requires individuals to come in to study it from the Department of Labor. So at issue was the finding that Bank of America was using inappropriate selection criteria. So these selection criteria that they were using were unfair and discriminatory, and that led to racially disparate impacts on employment, so racially adverse impacts. And these criteria included credit checks and evaluations of compatibility of work hours used to judge Black applicants' qualifications differently. So you might remember from our video in chapter 6 that we talked about some of the downsides of using credit checks in organizations for selection, right? And so this is one example of how that can play out in real life. In terms of evaluations of compatibility of work hours, this would fall under the category of biodata that we talked about from chapter 6. And again, this can also create adverse impacts against groups of individuals. So organizations should be very careful when they're determining what they're using for their selection methods, and make sure that they are fair and that they won't cause discrimination against any groups of individuals. So in terms of determining adverse impact, there are some steps involved in the case. So we'll talk about these broadly first, then I'll go into more detail on each. In step one, the plaintiff, so the plaintiff is the person who brings the case, and this is typically someone from the protected group who feels that their group is being discriminated against. They might approach an attorney, and the attorney will look into it, and then the attorney will bring the case, and they have the responsibility of demonstrating adverse impact. So that's called the burden of proof. So initially, the burden of proof is unfortunately on the group that's being discriminated against through their attorney. Step two is that the employer can demonstrate the validity of the measures that they're using, the tests or the measures that they're using for selection. And so you might remember that I said that it's important to have tests that are legally defensible, and this is how that would play out in real life. Step three, the plaintiff determines other predictors were available. So the employer, if they are able to demonstrate that the test is valid for predicting job performance, so that would involve showing content validity, construct validity, and criterion-related validity. If the employer is able to determine that the test is valid and prove that, the plaintiff can then say, okay, well, here are some other predictors that were available. Here are some other selection methods that you could have used that are equally valid but don't demonstrate adverse impact. So let's go through these in a little bit more detail. Okay, so what does the plaintiff or the person bringing the case need to do to demonstrate adverse impact? Okay, so they use what we call the 4/5 rule or the 80% rule that I mentioned earlier. And let's talk a little bit more about what that actually means. This is based on the selection ratio. So again, the selection ratio is the number of people who are hired for a position divided by the number of people who applied for the position. So the number of people who were actually hired divided by the number of people who were applicants for that position. For example, if I only hire one person and I have 100 applicants, and this scenario is very common in academia. So when we hire a new faculty member, we are typically only hiring one person, but we might have 100 applicants or more for that position. In this case, our selection ratio is one hire divided by 100 applicants, and that results in 0.01 or 1%. Our selection ratio in this case is 1%, which is very small. As another example on the other extreme end, if we were hiring 100 individuals, say for entry-level positions, and we had 100 applicants, then our selection ratio would be 100 hires divided by 100 applicants, which equals 1 or 100%. This is a very large selection ratio. And as a side note, you wouldn't necessarily even need to use any selection procedures if you had a selection ratio of 1 or 100%, right? Because there's no need to determine who's going to be best in terms of hiring if you're hiring everyone. So this gets at the idea that our validity becomes much more important as our selection ratio gets smaller. Okay, so back to adverse impact. Selection ratios must be roughly equivalent between different groups of individuals. So what do we mean by that? We mean that, in other words, organizations cannot be more stringent when hiring from one group versus another group, or more selective when hiring from one group versus another group. So, for example, if they are hiring only a certain percentage of white participants, they should also be hiring that same percentage of Black applicants. The selection ratios, or the degree to which they are more stringent, cannot differ based on the race, ethnicity, skin color, national origin, religion, or gender of the applicants. So, how do we determine what we mean by roughly equivalent? And by roughly equivalent, we mean that the selection ratio for one group must be at least 4/5 or 80% of the selection ratio for the other group. So in other words, this is not based on straight up numbers of people being hired. So if you just looked at an organization and say they hired 5 white individuals in a given year and 3 black individuals in a given year, that doesn't tell us all the information that we need when we're determining adverse impact, because we need to know how many white individuals applied and how many black individuals applied. So let's go through an example. If 1,000 white individuals and 100 black individuals applied for job openings, and the organization hired 100 of the white applicants and 9 of the black applicants, is it in violation of the 4/5 rule? So in terms of steps, step 1, we would calculate the selection ratio for each group. And again, this is the number of people who were hired divided by the number of people who applied. For black applicants, we have a selection ratio of 9 out of 100, so that would be 0.09 or 9%. For white applicants, we have 100 out of 1,000 applicants, which is 0.1 or 10%. And so what we need to determine next is whether 0.9 or 0.09 or 9% is within 4/5 or 80% of 10%. So we divide the selection ratio for black applicants by the selection ratio for white applicants. 0.09 divided by 0.10 is 90%. So 90% is greater than 80%. So in other words, the selection ratio for black applicants is similar enough to, in the eyes of the U.S. law, the selection ratio for white applicants, because it's 90%. If it was 70%, that's less than 80%, so that they would demonstrate adverse impact. But in this case, this example that I'm giving you is 90%. So the employer would be not in violation of the 4/5 rule, and adverse impact would not be demonstrated. Let's go through another example. So if 1,000 white people and 100 black people apply for job openings, and the organization hired 900 of the white applicants and 70 of the black applicants, is it in violation of the 4/5 rule? So step 1, we calculate the selection ratio for each group, the number of people hired divided by the number who applied. So for black applicants, we have 70 out of 100 or 70%. For white applicants, we have 900 out of 1,000 or 90%. So we've got to determine whether 70% is 4/5 or 80% of 90%. So we divide that selection ratio for the black applicants by the selection ratio for the white applicants. And in fact, we find that it is 78%, which is less than 80%. So in other words, the selection ratio for black applicants in the eyes of the U.S. law is too different. It's greater than 80% from the selection ratio for white applicants. And in fact, the employer in this case would be in violation of the 4/5 rule, and adverse impact would be demonstrated. Okay, so that was step 1 in terms of demonstrating adverse impact. In terms of step 2, the employer would then be given the opportunity to try to defend their test that they're using or their selection procedures by demonstrating validity. So in other words, once the plaintiff or the person who brought the case has shown that adverse impact exists, that burden of proof that I mentioned earlier shifts to the employer, the employing organization. And the employer may defend their selection procedure by showing its validity. The steps for determining validity are in the uniform guidelines, and we've been talking about those in our class this semester. They would need to demonstrate content validity. So does the test cover the full domain of the job? Construct validity. So is the test valid for the constructs that it is trying to assess? And of course, criterion-related validity. So does the test actually predict future performance on the job. Okay, so if the employer is able to demonstrate that their selection procedures are valid, then we move on to step 3, where the plaintiff, or the person who brought the case, demonstrates that other predictors were available that were equally valid. So if the employer can show that their procedure is valid, their last recourse for the plaintiff is to show that those equally valid procedures are available. And if other options that do not have adverse impact are in fact available, the plaintiff should win the case. So this gave you an overview of legal issues in hiring and selection, and specifically around adverse impact and disparate treatment.